Let us look into the nature of section 52. Is section 52 very exhaustive? Of course it is, because there are many, it is probably one of the longest provisions in the Indian Copyright Act, and it has many provisions which exhaustively provides the situations in which individuals can exercise fair use. In Oxford University Press versus Narendra Publishing, it said that section 52, the court said that section 52 only provides the broad heads and resort must be made to certain principles. Now what are these certain principles is important. Now as we have looked into the previous slides, courts across jurisdiction considered some of the 4-factor tests to be the ground principles or the ground norms for determining fair use. So similarly, in the context of Indian fair dealing under section 52, along with the broad heads of section 52, will it be important to consider these principles is a question that needs to be answered. In the case of Oxford University Press versus Narendra Publishing House, the Delhi High Court said that we must resort to such principles. Now the important question then is, if section 52 provides an exhaustive guide of fair use principles, then what is the further necessity of having section the principles that are usually referred to. Now if purpose of use is clearly established under section 52, should manner of use be determined by virtue of those principles is an important question. Now, and should we, by virtue of these principles laid down in the Oxford University Press versus Narendra Publishing House, should we be bound by only the 4-factor test, or should we also look into other principles that you might encounter in dealing or in scoping fair use? Now transformative and non-transformative uses are both fair dealing under the Indian law. In Indian law, you have a wide variety of exceptions which allow you to exactly make a copy in a limited sense to a limited extent, but at the same time it also allows certain transformative uses, especially in case of software, private criticism of review. By virtue of such exceptions, they allow you to make transformative uses of the work. Furthermore, in certain cases, fair use or fair dealing under section 52 allows you to make full copies. For example, section 52 clause Q of the Copyright Act allows reproduction or publication of certain government works, including judicial decisions, and this can be done by reproducing the whole text without any limitation. Now here, if you try and determine along with this section certain broad principles that the court asked us to consider in relation to fair use, you would be unnecessarily or unwarrantedly you will be curtailing fair use. So the question is whether such additional principles should be considered. Second, for example, where fair use is entirely exempted is in relation to section 52 ZC, which was added by the 2012 amendment, wherein importation of copies of literary or artistic work such as labels, logos and company promotional or explanatory material, which is purely incidental to importation of other goods or products. Now these shall not be considered as infringement. Now if you look into the wider scope of this provision, any incidental copying of these promotional material in full is actually allowed under section 52. Whether this should be treated within the general parameters of section 52 is an important question, although section 52 ZC by virtue of the 2012 amendment has introduced it into section 52. Most importantly, what should be considered in the context of section 52 is section 52 is largely to be judged for its consistency with the TRIPS agreement. It is the agreement on trade related aspects of intellectual property rights, which India signed in 1994 and which has come into force since then, and we are expected to be in compliance with article 9(2) and article 13 of the TRIPS agreement. What does article 13 say? It says that members shall confine limitations or exceptions to exclusive right to certain special cases, A. Second, which do not conflict with the normal exploitation of the work, and third, which do not unreasonably prejudice the legitimate interest of the right holder. The same language is used in section 9(2), article 9(2) of the Berne Convention. However, the word right holder is replaced by the word author in the Berne Convention. This provision came to be tested in one of the WTO dispute settlement panels, that is section 110 of the Fairness in Music Licensing Act of the United States was challenged by European Union. And what this particular provision did in the United States was it allowed certain exceptions called as the home style exception and the business style exception to bars and restaurants and other hotels with certain limited space capacity and which used certain amplifiers to broadcast music. Now, Europeans claim that this kind of exception is so broad that it actually conflicts with the normal exploitation of the right of the copyright holders and hence would violate Article 13 of the TRIPS agreement. The WTO dispute settlement came to a conclusion that the home style exception was indeed limited because it actually defined the nature of establishment vis-a-vis the space and also the amplifiers, but the business style exemption was not, because it went beyond the limited exception that is envisaged in the Article 13. Suffice it is to understand at this moment that the home style exemption was allowed by the panel because of its limited nature and because it would not usually normally exploit with the right of the copyright holder and would not unreasonably prejudice his interest. Now, how is fair dealing of musical works treated in the Indian context? Let us look through some cases now. In Soup Cassettes Industries versus Hamar Television, the question was whether if the defendant engaged in playing musical albums of the plaintiff's work as part of the news channel, should that be exempted? Now, can the defendant rely, for example, on section 52(1)(a)(2) and section 52(1)(b)(2) of the Act and then claim that these showing of musical albums is part of current reportage or reporting of current events? Now, the question, it was in this case the court held that there must be a quantitative test and it is important, but it is not the only criterion. Quality would be equally important in case of musical work, where even taking of a single note may lead to infringement. Infringement is also possible from the point of view of a lay listener if it formed an essential part of the copyrighted act. In this case, that section 52 must be confined to purposes limited therein, in the sense that the criticism or review or reportage of the events. And in this case, if you look into the act of defendants, they were using musical albums, and once they showed many of these, irrespective of whether they actually were confined to the purposes mentioned therein, that is criticism of or review or reportage of the current events, they went beyond and showed it as entertainment videos. So, court did not find linkages between the infringing act and the defense provided in section 52 after reviewing of the log table that is usually maintained by the channels, and it went on to say that it amounted to infringement. The court laid down certain principles, certain 13 principles, which I call as Super 13, and these principles can guide us in understanding the nature of fair dealing in India under section 52. So, the court said it is not possible, first of all, to define the broader contours of fair dealing. Second, whether it is a question of fact, degree and impression would depend on each and every case. And third, the length of the extract may be important, however, even taking of small extracts may lead to an infringement. Fourth, the right to criticize not only the form, style, etc., but also the underlying doctrine or principles exists as part of fair use. Fifth, what constitutes current events, etc., and in determining these, the courts must generally adopt a liberal approach and must not be restricted by by virtue of certain structural definitions. Sixth, how to judge infringement vis-a-vis fair use must be judged from a reasonable man's perspective, that is a fair-minded person or a lay hearer as the court calls it, and these tests would be important in ascertaining infringement vis-a-vis fair use. Quantitative and qualitative must be balanced, both those factors must be balanced. Especially the court said that injunction should not be granted on the ground of confidentiality, since confidentiality is a different ground altogether, especially when it is contrary to public policy. Free speech can be a ground, however liability may be compensatory in such cases. So, wherever there is a question of free speech, the court must use the compensatory liability regime rather than the injunctive relief system for allowing fair use of certain works. Furthermore, motive of the use is important whether injunction ought to be granted or not. It means if the motive is way beyond the usual case of commercial nature, then if there is some higher norm that is important for as a matter of public policy, then it must be allowed. Mere commercial use, however, is not unfair, and it not lead to finding of infringement. It means fair dealing of works can also be allowed for commercial purposes. Transformative uses may be fair in certain cases. So these are the broad principles that were laid down in this case.